MSW Media.
I signed an order appointing Jack Smith.
And nobody knows you.
And those who say Jack is a fanatic.
Mr. Smith is a veteran career prosecutor.
Wait, what law have I broken?
The events leading up to and on January 6th, classified documents and other presidential records.
You understand what prison is?
Send me to jail.
Welcome to episode 86 of Jack, the podcast about all things special counsel. Given whether the special counsel is actually doing anything right now because everything's on hold, that's something else we can talk about. But it's Sunday, July 21st, 2024. I'm Allison Gill.
And I'm Andy McCabe. All right. As you all know by now, Judge Eileen Cannon has dismissed the Florida case against Trump, citing Clarence Thomas, that Special Counsel Jack Smith was appointed without having been appointed and confirmed by the Congress, and also without Congress passing a law specifically creating his office. So we discussed that in detail in a bonus episode earlier in the week. And today, we're going to discuss Jack Smith's intent to appeal that ruling.
Ah, yes. And we're also going to take a look at a case of a January 6th insurrectionist whose motion for release based on the Supreme Court's ruling in the Fischer case has been denied by Judge Lamberth, who's a Reagan appointee. But before we get to all of any of that, let's do an installment of Good Week, Bad Week.
I mean, this could take the rest of the hour. What a week. Jeez. It's been
the longest decade this week.
Exactly.
Yeah.
I mean, okay, so we started Saturday with an assassination attempt on former President Trump. I mean, I think that alone puts you in really bad week if you're Trump, but you know, he survived it. So there's a bright side, I guess.
And there's so much going on. We're going to have to follow these investigations into the Secret Service and their deficiencies fairly closely. And, you know, the FBI seized 2 of his phones, went in there, said they don't have enough to develop a motive based on what they found in there. This guy seemingly, apparently able to stay off social media in this day and age is kind of, I don't know, impressive. And not in a good way. I'm not saying like, hey, well done. You know, just it's interesting. It's a point of interest, I think, for the FBI. They do know that he registered as a Republican a couple of days after his 18th birthday. But that's, you know, that, and I think his final search on the internet was for pornography. He also looked for pictures of both Trump and Biden, and also Chris Wray, the FBI director, and Merrick Garland. So he was very angry, I think, with the government in general. I think, and, you know, he turned up on a database developed by the Trump campaign, as his father did, at least, as a high potential to be a gun owner and somebody who could be flippable to Trump. But seems like his father, at least, identified as a libertarian.
That's right.
And, you know, I remember Donald Trump at the Libertarian Convention getting booed off the stage.
Not a good day for him on that one.
No, very bad day for him. And we still don't have any medical reports from the Trump campaign or the Trump camp about what happened, his treatment, diagnosis, prognosis after he got hit in the ear with something. But, you know, that doesn't take away from the fact that somebody was shooting at him. So,
yeah, no
hence
question.
The assassination attempt. And that was going to be my question for you, the FBI expert, because it seems to, if the FBI refers to something as an assassination attempt, they do that without prescribing or being able to prescribe any motive, right? It's just if somebody takes a shot at a high political figure, whether they hit, miss, or what they were thinking is not relevant to whether or not it was an assassination attempt. Do I have that right?
Well, it's interesting at the initial point of any investigation of something like this, or a mass shooting, or maybe an attempted terrorist attack, people make a lot of, there's a lot of focus on how the FBI refers to the investigation. Are they calling it domestic terrorism? Are they calling it an assassination? And the fact is, how they think about their investigation and how they refer to it is really based on a very preliminary analysis of the circumstances. Here, you have someone who clearly tried to kill the leading candidate for a particular political party, obviously Donald Trump, the now nominee, as of last Saturday, the presumptive nominee. So those circumstances alone are enough for the FBI to talk about this as an attempted assassination. That's not the same as actually charging someone with assassination, which is a federal crime. And it's the same is true in a terrorism situation. We might say, we think this is potentially an act of, let's say, domestic terrorism. We're assigning it to be investigated by our counterterrorism division. Those are all very significant decisions, but it's not a fait accompli until somebody's actually charged with something. Of course, domestic terrorism, there is no charge, but the point I'm trying to make.
Right.
So I think it's pretty clear that they were reacting to the circumstances. I don't think it's inaccurate at all to call this an attempted assassination. Of course, there'll be no charge here since he so far is the only person they're looking at. They've had no indication anybody else might be involved. He also had some interesting stuff with him or nearby. He had what's described as a rudimentary explosive device in his car. He also had a ballistic vest in his car. He had a drone in the car, additional ammunition. At home,
he had a transmitter with him on the roof, right? Something that
fireworks remote transmitter, which could have been used. He may have intended to use that with the explosive device to create a diversion. That's a I don't want to say common because these things aren't that common, but that's a tactic that assassins and terrorists have used in the past. He had additional stuff at home, many other guns, more explosives, other cell phones, hard drives and a laptop. So they're sorting through all that. I think at this point, it's too early to say conclusively what they think of this guy. But the fact that there's not any indication of a very strong ideological affiliation or even political affiliation, I think is an interesting fact. You have his registration as a Republican when he was like the day after he turned 18 or something like that. I don't know that that's a huge indicator, especially for someone that young. There was talk about a donation to a Democratic organization, although I think that donation is somewhat questionable at this point. They're trying to sort out exactly who did that. It may have been someone with a similar name. So the fact that there's no other evidence that indicates strong political belief, combined with the fact that he was also looking at the dates of the DNC and information about President Biden, information about Merrick Garland and Chris Wray, I think to me, it seems at least leaning in the direction that this was a guy who wanted to go out and do something that he thought was bold, that might be satisfying to him in some bizarre and disturbed way, a way of addressing his grievance, maybe the way that he felt like life had treated him and people have been ignoring him. Some people do things like this simply to make a name for themselves. I mean, think about John Hinckley. Did it to try to impress Jodie Foster, which is insane, but that's why he did it. So we could, at the end of the day, be looking at a really unsatisfying answer along those lines.
Yeah, I tend to agree with you on that. And I think he did. I think Tom Winter, at least at NBC, looked into the donation, and it's his name and it matches his address, and it was where he lived with his parents.
Yeah, sure.
But again, that's 9 months before he turned 18. So again, not really indicative of much other than just kind of one of the, like a lone wolf chaos agent guy,
Yeah. It's not the same as like the congressional baseball shooter who had a whole list of Republican potential targets and somewhat of a history of supporting liberal causes and things like that. That was a easier situation to make a determination that that was truly an attempted political assassination.
Mm-hmm. Yeah, and I think that they're gonna not just look at his phones and say, "Oh, we give up." They'll go to his school, to computers he logged into. They'll look at logs and see, because if he's building explosive devices or has rudimentary explosive devices, maybe he looked that up in a library book he checked out.
Exactly.
Or something else besides his cell phone. I think there were 2 cell phones in this case. But they're supposed to leave no stone unturned as far as investigating his.
That's how we do it. Yes.
I'm just thinking of the Mar-a-Lago. Let's not go into that closet situation. But
yeah.
He also had sights on Christopher Wray, and somebody actually was just charged in Atlanta for death threats against the director of the FBI. So. We'll, of course, not linked to the assassination attempt, but bad week as far as that's concerned. And then, of course, the news this week, we had the RNC happening, we had JD Vance announced, and still none of that really steered the media away from talking about Biden and his age and his performance at the debate. So it's been a very long week, at least I know for a lot of us and a lot of folks listening. But did you watch his RNC speech? Because the media was saying, oh, he's a new guy, he's serene, he's going to unify, and all he had to do was stay on prompter for 60 minutes, and he went off prompter for another 30 and went back to the exact same Trump that we've all seen for the last however many years. So I'm that anyone was surprised by that is surprising to me. Like, people don't change, especially people like Trump. So,
yeah, change not common in, what is he, 77-year-old narcissist? It's just kind of you're pretty much who you are and who you're going to be at that point. I'm sure he was shocked and disturbed by what happened on Saturday. I mean, we all should have been. It's just a terrible thing. It's not how we want to see political issues getting resolved in this country, although we have a deep, long, disturbing history of things like that. But we hope to try to rise above it. And I'm sure it affected him, but yeah, he's not going to change who he is. And I think that I did not listen to the speech last night. I just kind of couldn't. I
didn't watch it.
I couldn't put the energy together to sit there for 90 minutes. Like, no, thank you. But
I actually watched House of the Dragon, which is actually to escape, but it's actually quite similar to what's going on. It's a little too on the nose with what's going on in the real world. I was like, I'll watch this. It'll be totally different. And
not really.
It wasn't.
Not so much.
But
I really only watched the Tour de France this month. So that's, I always have a good race to watch at night, which is great. But yeah, I'm not surprised at all. He gave the long kind of, discussion, his description of what had happened at the rally, and that's compelling to hear from a victim talk about what happened to them. But that he could only do that for so long, and then it was just back off the teleprompter and into the standard list of grievance and talking about himself and how horrible other people are. Not a lot, from what I understand, not a lot of talk about plan for the future of America or anything like that. But
no, and he avoided sharks and batteries. So that
hit the Hannibal Lecter.
But he talked about Hannibal Lecter. Yeah, he talked about the late great Hannibal Lecter. First of all, I don't think did he die? I don't remember. I didn't see the third movie, but anyway,
not a real guy though, so it doesn't matter.
Also, not a real guy, Andy. I guess if you want to get technical about it. With your, you worked for the FBI, you got to be all technical about who exists in real life or whatever.
It's all about the facts, ma'am. I get it.
You're a real Joe Friday.
I know. I can't get over it. I just, I can't get past those things like not a real person and, fictitious character. But whatever. Okay.
Yeah.
Don't
and
stop
JD
him.
Vance's
He's on a roll.
speech was boring. He's a terrifying figure, just funded by Peter Thiel and Elon Musk, who's destroying Twitter. Like, it's just, everything is kind of up in the air right now. And everything, is up in the air for Jack Smith right now. We're in limbo because the Supreme Court has not sent the immunity case back down to the circuit court. They could have done it immediately, but they wanted to give everybody time to file a rehearing, which was not going to happen. And so we've got nothing going on in the DC case until the first week of August, at least. And as we know with the Florida case, Cannon has dismissed that, and we're waiting for the appeal from Jack Smith. And we'll talk about that after this quick break. So everybody stick around. We'll be right back.
Welcome back. Okay, on July 17th, Jay Bratt and David Harbaugh filed their notice of appeal to the 11th Circuit on behalf of the special counsel's office. Now, during the bonus episode, we heard from a spokesperson for Jack Smith that they intended to file that appeal. And of course, since then, we got the official notice. It's very brief. It says, the United States of America hereby gives notice that it appeals to the United States Court of Appeals for the 11th Circuit from the order of the District Court entered July 15th, 2024, docket entry 672. Now, that's a reference to Judge Cannon's ruling on Trump's motion to dismiss the superseding indictment based on the inappropriate appointment and funding of the special counsel.
Yeah, 93 pages worth. And even though she didn't consider the funding of special counsel because she just dismissed on inappropriate appointment, she went on to tell us how she also thinks he's inappropriately funded.
Yeah.
So what I'm looking for now, Andy, what everybody should be waiting for is to see whether Jack Smith files a motion to expedite the appeal and whether he will seek to have her removed from the case. So let's start with a motion for expedited appeal.
Sure.
But right now I'm on the docket. It has not come up yet. It's not there. I'll check again before we say goodbye on this particular episode. But it's not there. It's just so far the latest thing is that notice of appeal that you just read. But for the expedited appeal, first, it's important to understand the reason Jack Smith filed this notice that you just read is that he intends to appeal is because the government has a very limited number of days to file a notice protecting its right to file the full appeal. And we've seen this time and again with every appeal to a circuit court where the appellate, the person who's filing the appeal files a notice that they're going to appeal. And that's like a space saver for them to now have a certain amount of time to file the full brief. And the government doesn't always follow up with a full appeal, but there's no reason to believe they won't do that here. They're totally going to appeal.
If not, just fold the tent, turn out the lights in the office and go home. Yeah, they're definitely going to follow up on this appeal. So we're waiting to get our hands on that thing.
Yeah. And once you file your notice to appeal, the government typically has 40 days to file its full record on appeal brief. And as Joyce Vance pointed out, she said appellate courts don't take evidence. They consider only material that was before the lower court, the trial court, including pleadings and transcripts. Appellate courts don't consider any information that isn't already in the record. That's from Rule 10, which is called the record on appeal. So if Jack Smith doesn't ask for an expedited schedule, the timeline gives him 40 days. That's the regular timeline. Then Trump would have 30 days to reply. And then the government would have 21 days to respond to Trump's reply. And if everyone used up the whole time, that puts us in October, though I doubt special counsel would use the entire 40 or 21 days to issue their brief. But I think they'll file for an expedited appeal here. We just haven't seen it. Or at least an expedited briefing schedule. Do you agree?
I do. Look, the clock is ticking for them, obviously. Though they don't talk about this publicly, I'm sure they're aware of the fact that we're not just closing in on the election, but closing in on the amount of time they'll have to work on this case in the event the election goes for Trump. And so I think they'll probably cut through their times as quickly as they can. So yeah, I agree with you. If they can get that thing done in less than 40 days, I think we'll see it.
Yeah, and they've done this before with the 11th Circuit and Judge Cannon.
That's right. And, they filed for an expedited briefing schedule in this case with the 11th Circuit before the special master case, which Judge Cannon lost and was forced to vacate her ruling. Now, Joyce goes on to say that if Jack Smith files for an expedited schedule and the 11th Circuit grants that request, that could be an early indicator that the 11th Circuit intends to overturn her ruling. Now, something else to keep in mind, once the 3-judge panel is assigned, and as of the day we record this, we don't have that assignment yet, those 3 judges will also decide whether or not to expedite the schedule, provided Jack Smith asks for it. If they do, the case must be fully briefed, meaning the government's brief, Trump's response, and the government's reply must be received 7 full days before oral argument is scheduled.
That's interesting. And I have to think that special counsel may have most of this brief ready to go. I mean, I would have, given the fact that this motion was made in February. Cannon sat on this motion to dismiss for 144 days.
It's amazing.
She also nudged Walt Nauta and Carlos de Oliveira to join the motion. Like, hey, guys, you have till July 10th to join this motion, or what, I can't remember, the June 10th maybe.
Don't you want to come to the party?
Yeah, hey, you might want to get in on this action. And she allowed amicus briefs and the oral arguments from amici, which is beyond bizarre. So even if they don't ask for an expedited briefing schedule, they most certainly won't wait the full 40 days to file the brief. I think they have most of it probably done already. And in the special master case that you just mentioned, the one that the 11th Circuit vacated for Judge Cannon, on September 30th, 2022, the Justice Department filed a motion with the 11th Circuit asking for an expedited briefing. They wanted the government's stuff due on October 14th, in 2 weeks, instead of 40 days. A response by Trump on November 4th, which gave him about, 21, 3 weeks?
3 weeks.
And then a reply from the Justice Department a week later. So they wanted to go 14 days, 21 days, and 7 days instead of 40, 30, and 21.
Right. But lawyers for Trump argued back then that he would be unfairly prejudiced by a shortened schedule, which included shorter deadlines and oral arguments at the court's earliest convenience. Trump wanted oral arguments in January, which is months later.
Of course he did.
Yeah. So they said no good cause has been shown as to why President Trump should have significantly less time than the government and less time than that provided under the rules to prepare and brief his arguments before this court in this unprecedented case. The appeals court granted the DOJ expedited briefing, but it gave Trump an extra week, which I like to refer to as the "oh, shut up" grant. You know, like you're not really with it, but you're like, all right, give him a week, and then I don't want to hear any more complaints. So essentially, all briefing papers were due by November 17th. So that expedited briefing schedule gave the parties 49 days as opposed to the 91 days allowed by the regular rules. And today, we got notices to appear in the 11th Circuit from Trump lawyer Emile Beauvais and government attorney James Pierce. Though Emile Beauvais made a clerical error and used another person's account to file his appearance, so he had to go back and correct his mistake.
Oops.
Yes.
James Pierce.
Can I use your login? I mean, come on. It's the 11th Circuit.
What? Right? Okay. Yeah, no, James Pierce, who's going to argue for the government, he's written multiple briefs and argued several times for special counsel, including the brief opposing immunity filed with Judge Chutkan way long time ago. And he was part of the oral arguments for Cannon's mini trial on the special counsel's appointment and funding. So then the only question, we still don't know if he's going to file for an expedited briefing schedule, but I imagine he will. But that leaves the question, as we wait for this appellate brief, whether Jack Smith will ask for Cannon's removal. He didn't say that, but I don't know that you necessarily do make that notice, or if it's part of your appeal. I just don't know enough about the appellate court rules. I don't know if you have to notice the court. If you have to tell them, hey, I'm also going to ask to have her removed from the case. I don't know if you have to do that or not. But we'll know once we get the brief. But that brief will be at least, a month from now, if you think about it, because we have to wait for him to file the expedited briefing schedule. We have to get an approval, if there's an approval for an expedited briefing schedule. And then they'll probably give the government at least 2 weeks. I imagine that's what the government will ask for around that. So we're looking at, it's going to be a while.
Definitely. And the question about the request for removal, I'm not sure about that either, to be perfectly honest. It's so rare. There's not a lot of examples to draw from. It could be that you would include it in your initial filing, or it could be a situation where they only ask for it in the event that their appeal is granted, or it could be they don't ask for it at all, and they just leave it up to the court's discretion and are satisfied to live with the result. I find that option really hard to believe, but we'll see with the motion itself whether or not it's included there. If it is, then we have the question answered. If it's not, I think it's still kind of an issue hanging out there that we'll have to see how it develops.
Mm-hmm. Yeah, and it'll be interesting to see if they do ask for removal on what grounds, because like you said, it's really, really rare, and especially in the 11th Circuit, where you have to make like extrajudicial, super biased statements in order to be removed. We do know, and I think we talked about this last week, that 2 judges, including her senior judge in her district, asked her early on to remove herself from the case, and she refused, which is her right. Also, we had that witness list thing she ordered to be released,
Yep.
and there was a motion for reconsideration, and she reversed herself. So that kind of puts her back at 0.
Right.
Then there's the special master thing, but you can't really rely on something that had already happened and you haven't asked for a removal yet. But I know that they will at least on the appeal talk about the clear error on the law in dismissing the case. But whether that combined with special counsel and a couple of other things alone are enough to get her removed from the case, I don't know. I really don't know. I've never seen a judge get removed from a case. I've only been following a couple of really specific investigations for less than 10 years, but I've never seen anything like that.
Nor have I. It never came up in any case that I worked on during my time in government. I agree with you. There's got to be, typically, as I understand, and again, this is from talking to people who've had rare experiences with it, it happens in cases where there is some articulable cause, not necessarily proven, but a good argument that the judge has some sort of underlying bias, or that the circumstances around the motion could lead people to believe that there was some bias. Not that there definitely is, but that's like a kind of like you have to avoid the appearance of impropriety, right?
Mm-hmm.
So how they think about that, I don't know. I think things like reversing herself on the witness list issue actually goes in her favor, right? So it's not clear. But one thing that I was thinking about here as we were getting ready for this show, when you think about the fact that the 11th Circuit doesn't hear witnesses, doesn't see exhibits, anything like that, they just simply look at the record in the case. Now, her decisions as to how she handled this motion maybe are a little more crazy like a fox than they were. Having the oral arguments seemed crazy. Having amicus briefs seemed nutty. Letting the amicus present for 30 minutes each during the hearing totally never happens in a district court case. And I think many of us, myself included, so shame on me, were like, oh my God, she's crazy. She doesn't know what she's doing. We were taking it simply as a sign of incompetence or something along those lines. And then she comes out with this 93-page massive order that really goes deep on all sorts of almost like Supreme Court level arguments and justification and historical research and semantic arguments, and this very expansive, she was creating a really broad, detailed, multifaceted record upon which to make this decision, even if you disagree with the decision, which of course I do, but she went way out of her way to write that thing and probably had been doing it for months. So now it looks like all those crazy decisions to have this long hearing and having all these people weigh in, it looks a little more premeditated. Like she wanted to put 10 tons of stuff on the record, knowing she was going to go this way in an effort to put as much in front of the 11th Circuit as humanly possible.
Yeah, that is a really good point because like you said, they can only take what's in the record. And if her record is
massive,
30 boxes worth of
nonsense,
then, there you go.
I mean, it's like she was taking her best swing. You know what I mean? Like she knew that the stakes would be high on this one. So she's really building a case. So anyway, we'll see.
And there's,
how it ends
by
up.
the way, a couple of other filings here on the docket. Nothing with the expedited request or anything from the government regarding the appeal, but there was a appearance for counsel from Jay Bratt filed
Okay.
for the government, an appearance of counsel for John Pelletieri for the government. So we got a couple of additional lawyers filing for appearance in the appeals court, which you have to do if you want to argue, brief, anything. So it makes sense that Pierce, Bratt, all the lawyers for the special counsel's office that are going to write the briefings and appear at oral argument would have to file a notice of appearance.
Yeah. Doesn't mean every one of those folks will stand up and make an argument. It just means like that's their roster that they'll draw from. Each one of them has to be admitted to the bar of the 11th Circuit, which is kind of an administrative matter. It's not like you have to sit for another exam or anything. But yeah, so this is all just very standard kind of administrative boxes they got to check off. Yep.
And so they're doing it. And they did it right. They used their own accounts to file their own ECF accounts.
Good job, fellas. Good job.
Motions for appearance. High five.
No sharing the passwords. Come on. It's all about cybersecurity.
Oh, my goodness. All right. We have more to get to, including some stuff that's going on with the Fischer decision, which, of course, as you know, Trump is, in the D.C. case, charged with 1512C2 and 1512K, and the 1512K hinges on the 1512C2. And so we'll talk about that. But we do have to take another quick break. Everybody stick around. We'll be right back. Hey, everybody. Welcome back. All right. We're starting to get more information on the fallout of the Supreme Court's decision in the Fischer case. You'll remember there was an insurrectionist who attacked the Capitol named Fischer, who filed with Judge Nichols, a Trump appointee, in the district court, saying that his case should be dismissed because 1512C2, which is obstructing an official proceeding, actually relies on the language in 1512C1, meaning he had to just break into the building to stop the peaceful transfer of power isn't enough of obstructing an official proceeding. It actually has to involve the obstruction of documents or creating false documents or destroying documents. So that 1512C1 and 1512C2 are connected. And as you know, Andy, there were several filings made by Jack Smith about Trump's 1512C2 and 1512K charges, saying that our charges in this indictment stand even if the Supreme Court guts 1512C2 on well, they don't say guts, but they say on a narrower interpretation of 1512C2.
It's the legal version of guts.
And so that's what the Fischer case was. And Nichols, by the way, was the only judge out of, I think, 12, at least a dozen, who decided that 1512C2 has to have something to do with documents. The other judges said, no, we interpret the law differently. The government said we interpret the law differently. Supreme Court sided with Judge Nichols. And this is coming now from your colleague, Hannah Rabinowitz, over at CNN. Weeks after the Supreme Court narrowed how the Justice Department can pursue obstruction charges in January 6th cases, federal prosecutors are beginning to offer retooled plea deals or drop that specific charge against members of the mob that attacked the Capitol. These developments are slowly trickling out in court filings, I should say, as prosecutors make clear that they plan to continue holding the rioters accountable within the constraints of the Supreme Court decision. According to Justice Department statistics, there are about 259 defendants facing this charge, 1512C2. And there were 259 when the Supreme Court issued its ruling that narrowed how 1512C2 can be applied. Among those individuals are 5 alleged members of the Proud Boys. Though they aren't accused of being leaders, they're not the seditious conspiracy Proud Boys. Right. They're just obstructing an official proceeding Proud Boys.
The general obstructors, not the full-on organizing of the obstruction.
Mm-hmm. So they aren't charged with coordinating it or anything. They are Arthur Jackman, Edward George Jr., Paul Ray, and the father and son duo of Kevin and Nate Tuck. And in a court filing just this past Monday, prosecutors said that each defendant has been offered a plea deal, a new one that does not include the obstruction charge. And now if they decline that deal, prosecutors said they would move to dismiss the charge and take the men to trial on their other crimes. Okay. So it's again, and this is kind of happening with a lot of these cases as the Justice Department sort of weeds through what they need to do with the new interpretation of the law.
That's right. That's right. We knew this was going to happen. And so these are kind of our first indications of how they're thinking about it. So Hannah goes on to say, the Supreme Court opinion gave the DOJ room to bring the charge against some rioters who attempted to impact documents and, quote, other things used in an official proceeding. And prosecutors would have to prove that each defendant falls into that category by connecting them to the Electoral College certificates that Congress was certifying on January 6, 2021. I should say here, that's one theory of how you could continue to push this charge against one of those defendants. There's also other ways. If you had a defendant who, let's say, broke into a congressman's office and destroyed documents in there, you might be able to use that activity. But nevertheless, Hannah goes on to say, prosecutors already moved to dismiss the charge against some defendants, including Mark Sahadi, a Massachusetts man who runs a straight pride group, and Beverly Hills salon owner Gina Bisignano. I hope I'm pronouncing that correctly. In Bisignano's case, prosecutors wrote in court filings that they would, quote, need additional time to evaluate its prosecution of the obstruction charge and are electing to drop the charge in the aim of keeping their current trial date.
So many things go into these decisions.
Yes. Yeah.
Like, oh, well, we've got a trial date coming up. And, you wonder, if I drop this charge, how does that impact the sentencing guidelines? Well, we've got a new case here that sort of gives us a window into that. Because a couple of days ago, on July 18th, Judge Royce Lamberth, as I said, he's a Reagan appointee, denied Alex Hostetter's motion to be released pending his appeal of his obstruction.
Right, so he's already convicted of 1512 and likely other charges as well, and he's currently serving time.
Yep, multiple charges. He was sentenced to 11 years in prison about 7, almost 8 months ago, last December. 11 years. He's the ex-cop, right?
Yes.
He brought the hatchet. That's that guy.
Yep.
And he filed a motion, let me out of prison. I'm appealing based on Supreme Court's decision in Fischer. You should let me out of prison while I'm appealing. But here, that was denied. Here's some of what the judge said in denying his release. He said, Mr. Hostetter has neither demonstrated by clear and convincing evidence that he poses no danger to the community, nor that his pending appeal, if successful, would even reduce his sentence by so much as to warrant his release, right? Like it might reduce his sentence, but not enough to let you out while you're appealing it. And here's some other verbiage from what the judge had to say. As already discussed, Mr. Hostetter has revealed his capacity for violence by bringing a weapon into a restricted area, spurring on a violent mob, and calling for the execution of public officials. Hostetter was impelled on January 6th by his ideological convictions, and by the time of sentencing, he had not abandoned the theories that motivated his illicit conduct. Quote, the election was stolen, and he still, quote, truly believed this. Indeed, Hostetter saw and continues to see it as his affirmative duty to act as he did that day, which raises the substantial risk that he would be willing to replicate his behavior, particularly considering that the next election is just a few months away. So you're extra dangerous, sir, right?
Yeah.
He actually said, I'll double down on what I did, why I was there, and that it was my oath to the country that drove me there. Hostetter points out, and the court recognizes, that due to his compliance with his pretrial release conditions and his stable personal life and lack of criminal history, the court did permit him to self-surrender rather than ordering him into custody immediately after sentencing. But the severity of his offenses, viewed in light of his conduct during sentencing and coupled with the looming election, persuade this court that the present risk of releasing Hostetter is too grave. The fact that the court has afforded Hostetter lenient custodial conditions in the past does not preclude the determination today that he represents a threat to the community if released. Then he goes on to say, moreover, even if Hostetter were not a risk to the community, he nevertheless bears the burden to show that his appeal is likely to result in a reduced sentence shorter than the sum of the time he's already served and the time that it will take for the D.C. Circuit to resolve his appeal. He argues that absent his 1512 convictions, the guideline sentence for his remaining offenses would be 6 to 12 months. But even if this is so, Hostetter too hastily presumes this court would necessarily give a guideline sentence on remand. In crafting its original sentence, the court considered the sentencing guidelines, but also made its own assessment, as it must, of the factual, personal, and historical circumstances surrounding his offense. While the Supreme Court's decision in Fischer may ultimately change the guidelines recommendation for Mr. Hostetter, Fischer does not dictate the court's application of discretion and the factors to Mr. Hostetter's remaining convictions. Okay, so the court may still consider Mr. Hostetter's serious conduct on January 6th, 2021 in its entirety, even if the Court of Appeals concludes that this conduct no longer constitutes a crime. To reduce his sentence from 135 months to 12 months would require this court to take a drastically different view of his conduct, and the court is not persuaded that the pending appeal in this case will have such an effect. Because Hostetter has not met his burden, your motion will not succeed, so it's denied. You cannot be released early while you're pending. So
I think one of the things that this really points out is the significance of acceptance of responsibility and remorse after you've been convicted. And I say that because, here clearly what the judge is saying is like, yeah, the fact that he's doubling down on everything he did really keeps this right in the hot zone of you're going to get hit pretty hard on sentencing. And this is something we've talked about a lot in the context of the Trump sentencing in New York. Now, I know there's all kinds of other issues there now because of his appeal, and he's going to make an immunity claim and everything else. That's somewhat confusing. But just on this straight up sentencing that ultimately Judge Merchan will have to give, even though a lot of things about his crime up there would raise the maybe presumption that he probably wouldn't get jail time. The fact that he has gone through this whole process and has absolutely zero acceptance of responsibility, that is a big, big factor to judges. And it is, I think, the worst thing he has going for him in that sentencing process.
Yeah, it's what jacked his disgorgement fines from Engoron up to $454 million, because Engoron said you are pathologically without remorse.
Right.
It's pathological. And I kind of wish Judge Lamberth had said that. Had you accepted responsibility and shown remorse,
we might be there.
We'd be in a different spot.
We'd be in a different spot, yeah, for sure.
But you were like, I'm going to do it again. And I really thought it was very excellent that the judge pointed out, we have an election coming up. You've shown you're real bad with elections. It's just, you and elections don't get along real well with as far as violence is concerned, Mr. Hatchett. So how about no, you don't get to get out of prison right before another election with the same candidate running that caused you to attack the Capitol the first time.
Yeah. And we're going to see a lot of these because those cases, the DOJ's got a lot they've got to figure out in these cases. I think most of the people that took convictions for 1512C2 also were convicted for other offenses, many of which were violent. So they're not going to get completely cut loose. So they'll all appeal. Many of them will have those charges, those convictions overturned on the 1512C2 issue. Then the question comes back to the district court to resentence. And I don't think this is the last one of these you're going to see.
No. Fortunately, there's a handful of them.
Yeah.
There's not many of the over 1,200 convictions and plea deals they've gotten. But I'm pretty confident because of Jack Smith's writing, because, Trump filed with Judge Cannon a motion to dismiss based on statutory ambiguity, right?
Yeah.
And Jack Smith wrote in response, yeah, no, sorry, even on the narrower reading, we don't have that decision yet. At the time, we didn't have the Fischer decision yet. It was still working its way up.
Yep.
And Jack Smith said, even on a narrower ruling, you can't possibly look me in the face and say, with your mouth, that you didn't obstruct procedural documents
via documents,
in this thing. You falsified, you were part of a scheme to falsify electoral certificates. That falls into this. And the Supreme Court actually mentioned that in their Fischer ruling. They said creating false evidence would fall under 1512c2 and our narrower interpretation of it, as if to say sending false, electoral certificates to Congress.
Straight up docs.
Falls under this thing.
It'll be interesting to see how the sequencing plays out with the immunity ruling work that has to go on, right? And is this something that they just kind of table until we figure out how much of this case is actually still alive and going forward after we go through all the machinations of what was core conduct, what was official conduct, what's left? Do you have enough evidence to prove those things? Even after that process, then he's got to make some decisions about what do you do with this 1512c2 charge? Do you stick with it and defend it and take it, or do you try to kind of narrow the scope of what you're doing, whatever's left of that, and just drop it entirely? So it's a lot.
I think the sequencing will be, they have to figure out the immunity thing first. Once discovery is agreed upon, they have to figure out the immunity thing first, because Robert said, you have to do this first. Right. This has to come at the early onset of a case to determine these, what's immune and what's not. And then, I think they'll go for trying to, if they have to redecide the case, maybe refile charges. I think they'll include the language, maybe, but they don't necessarily have to, because it looks clear to me that Jack Smith actually wrote this indictment with the narrower version of 1512c2 in mind.
Yeah, it's very possible they'll stick with it.
Yeah. All right, we're going to get to some listener questions. We do have to take one last quick break. If you have a question, there's a link in the show notes you can click to submit your question to us, and we will answer those questions right after this break. Stick around. We'll be right back.
Okay, welcome back. Here we are at the question part of the show. We have so many questions this week, and many of them have to do with what to expect on the appeal from Judge Cannon's order of dismissing the case in Florida. So I pulled a whole bunch of them up, AG, and I thought we could just kind of rip through them maybe kind of quickly to cover more ground here.
Yeah, sounds good.
This first one comes to us from Eric in the UK. And he says, when the appeal gets the 11th Circuit, what are the options? Could they refuse to hear it, so the dismissal of the indictment stands? Could they just tell Cannon she's wrong and to reconsider? What needs to happen for the appeal to be upheld and someone besides Cannon taking up the case? So that's a pretty good recitation of the options, Eric. They could refuse to hear the case, and if that happens, it's over. Case has been dismissed. We all walk away. Or they could take the case, which I think is the most likely alternative, and then it's up to them. If they think the judgment, they could affirm her judgment, and then the case is over, or they could overturn her judgment. And then if they do that, they'll give some instruction on what they want to do with the case. As far as keeping Cannon on it or not, that, as we discussed earlier in the show, comes down to whether or not Jack Smith and his team ask for that sort of relief. Do they ask for it in the initial motion, or do they make that request in the event they're successful on the appeal?
Yeah, and I think, again, we talked about whether or not he was going to ask for her removal, but I honestly don't think that the 11th Circuit will refuse to hear this case. They'll take it. And I'm pretty confident if Jack Smith asks for an expedited appeal, he'll get it, because we have precedent for that. We've seen it happen with this case.
Yep.
Right?
So they've kind of acknowledged the important nature of the case and the need to move the case forward in a quick manner, as quick as you can without compromising the rights of the defendant. So yeah, I think there's a decent chance that that'll happen.
Yeah, I agree. I agree with that. So I think, as far as Eric, your question goes, the thing that we just don't know for sure is whether or not he'll even ask to remove her from the case, and whether or not that would even be considered or granted by the 11th Circuit. It certainly would be appealed to the Supreme Court.
Yep, that's for sure. Okay, next question comes to us from Canadian Fangirl. She says, what is the role of Clarence Thomas in the 11th Circuit appeal? Can he get involved and shoot it down? So what she's referring to here is the fact that each Supreme Court justice has kind of an administrative sort of oversight responsibility for a different circuit. And it just so happens that the Supreme Court justice that oversees the 11th Circuit is Clarence Thomas. But his role in doing that is really pretty administrative. It's not substantive. He doesn't hear cases down there. He doesn't tell them which cases to hear and which ones to reject. So at the end of the day, I don't think Thomas really will have much of an effect on the appeal. Do you see it any differently?
No. And, generally what Thomas can do here is grant or deny what's called an administrative stay. And that's the stay to hold the proceeding until the Supreme Court rules more broadly on a longer stay. And so whenever you hear somebody say, Clarence Thomas or Alito has issued a stay, they've stopped the proceedings. Those are always temporary.
Yeah.
They're administrative. And that's kind of really the
biggest
limit of their
move.
reach.
Yeah. And that doesn't even happen until after the 11th Circuit has heard the case, has rendered a decision, and maybe until after the loser of that decision may request an en banc hearing of the entire 11th Circuit. And if that is granted, then that process takes place. And then the loser decides to appeal to the Supreme Court. In that moment, the appellant to the Supreme Court would say, hey, I want the case stayed until the Supreme Court reviews it. And that very first decision of issuing a temporary stay would be in Thomas's hands. So it's not really...
Mm-hmm. And not even the full stay, just the temporary stay.
Yeah, exactly.
Because he has to take the full stay consideration back to the full court.
Exactly.
Yeah. And you brought up a really good point, Andy. Appealing to the 11th Circuit, asking for a stay from the 11th Circuit, Justice Thomas has nothing to do with any of that.
Right.
All right. Next question from Julie. With Judge Cannon dismissing the Mar-a-Lago case, after Jack Smith appeals and hopefully wins, can't Trump appeal to the Supreme Court? Then could this crazy Supreme Court just rule in Trump's favor? Julie, yes. Yes, and yes.
Yes and yes.
No, I know. I will say, 5 years ago, I would have said it's only Justice Thomas who mentioned the appointment of Jack Smith in his immunity concurrence. And so
for no reason apparent to anyone on the planet other than him, but okay.
No dictum. Yeah. For any reason, I would have no reason to believe that any of the other justices would agree with him. However, today is not 5 years ago.
Yeah.
And so I honestly don't know. I honestly don't know whether the Supreme Court would find for Trump and say that I could very easily see them saying, hey, the appointment of special counsel needs a congressional law that's different from the one we have. I mean, they've done that already this term where a law wasn't enough. And so
I totally agree. The deck is wide open. They could, if the 11th Circuit takes the case and they render a decision that overturns Judge Cannon, so they rule for the prosecution, it's possible that the Supreme Court wouldn't even take the appeal. They might say, no, there's no inconsistency in the law. All the other cases go in the same direction. This one now goes in that direction. There's nothing for us to resolve. That would be terrific. Or they could go totally the other way. Take the case, stay everything until they went through their leisurely approach to it. And then
it would be next term.
Throw the whole thing out again.
This fall.
Yeah.
And I can hear them saying, this is an important question and we need to make a rule for the ages on whether or not special counsels are appointed properly and funded properly. It's long past due that we address these issues, etc. So, and here's where I think they could do it, because the law that allows Merrick Garland to appoint a special counsel was written before the special counsel regulations, as we knew them, the independent counsel regulations, expired.
Yeah.
Okay. And so I could see him saying, these new special counsel regulations, were written after that law, it sounds ridiculous.
There essentially is no specific law anymore, right? After the independent counsel law expired, DOJ reacted by just enacting their own regulations, enacting their own policies, and having them
based on a previous law.
Yeah. But Reno went before Congress and said, we don't need a law. We can just do this, by promulgating this rule for the department, which is in place because of, the judgment of the attorney general. And that's kind of one of the things that Cannon hinged her case on. You have no law, so it's not a real thing. But anyway, all right. So this next one, I'm going to kind of combine two questions because they both kind of go in the same direction. So this is from Paul from MoCo in the DMV, which those people where I live know that that's Montgomery County in the DC, Maryland, Virginia area. So there's your there's your local translation. So basically, Paul is asking a couple of questions, and he's concerned, how do these cases always seem to end up in the 11th Circuit? Would the judges on the 11th Circuit have been keeping close tabs on this case and digesting all the briefs and rulings in anticipation of an eventual appeal? So that's his question. And then we also get one from, I don't know how to pronounce this name. It's L''EAUX. Is that Lou?
Lou and Terry.
Lou and Terry, they are mother and daughter. I think Terry is the mom. In any case, they say, our question for you this week is the following. When Jack and the gang filed their appeal and recusal request, is she the person that goes before the 11th Circuit, or would that be Trump's lawyers? Are the appeal and the recusal two separate actions? And if so, would they be handled at the same time? Okay, so this all is kind of cuts at that question. It was how does this happen, right?
Right.
So generally, the 11th Circuit, they will not have been reading any of the filings in this case regarding this issue. They do not start considering this issue until somebody has requested an appeal and they have granted an appeal. And much like the Supreme Court did in the immunity issue, if they grant the appeal, they're going to say, we grant it on the following question, right? They're going to frame what the issue actually is, and then that will instruct the lawyers as to how they brief it. Once the lawyers submit their briefing, they can attach to it any documents that were in the record of the district court. So they might point to their earlier arguments. They might, and as we said,
amicus briefs
earlier, the amicus briefs, the testimony of the oral arguments, all that kind of stuff then becomes relevant for the 11th Circuit, and they will only really review that once they've gotten involved and start looking at the appeal.
Okay, interesting. And then as far as a recusal request, as we said earlier, I don't know whether that piggybacks on the appeal and they include it in there, or if they file it separately, and if they need to file a notice that they are going to ask for her removal. I simply don't know. I'll keep asking. I'll reach out to Steve Laddick. Maybe he knows.
Steve knows everything.
But I think part of the question was, is Judge Cannon the person? If so, let's say Jack Smith wants her removed from the case. Is she then?
Does she go argue for herself?
Right. Does she
no chance.
File her own briefings? Does she?
No, only the parties to the case go before the 11th Circuit. Now, no question, Judge Cannon's ruling dismissing the case in all of its 93-page grandeur will be central to this entire fight if, in fact, the 11th Circuit takes the appeal. That's what they'll be arguing about. The prosecution's memo will, even though, as you said earlier, they've probably done a lot of work on this, they've been anticipating it. That's true, but a lot of their work is really they can only do after they've seen what Judge Cannon's ruling was and what it was based on and what her logic and reasoning was, because that's what they're going to attack. And of course, the other side's going to come in and say, she was right. So although she won't be there, she doesn't get to argue. She doesn't, get to influence the court.
So she doesn't defend herself. If Jack Smith wants her off the case, she doesn't defend herself. Trump's lawyers defend her staying on the case.
That's my understanding. That's right.
Okay.
Yeah.
That's good to know.
Yeah.
Because I can imagine her having her clerks write up a reply brief for her to stay on the case. Like,
Madam Justice Cannon, may it please the court, I'd like to make arguments for myself. No, that's not going to happen.
Send in an amicus brief and have
friend of mine. All right, so last
literal
question.
Friend of the court.
Should we barrel into the last one? It's a shorty.
Yeah, let's go into the last one.
You can even have a yes/no answer if you want. This one comes from Barbara, and she says, of course, "Oh, most attractive podcast hosts," which I love. Do you think it's possible that Eileen Cannon wants to be a Supreme Court justice?
Every judge wants to be a Supreme Court justice.
That's like saying, do you think Congressman so-and-so wants to be president? Yes.
Yeah,
or
of them do. Do you think this gymnast wants to go to the Olympics?
Mm-hmm.
Yes. Of course she does. And we've seen Trump, praise her. And, I don't think he's, I know there was a fake tweet going around where he was offering her a job at the Supreme Court, which was fake. I don't think he specifically has dangled that in front of her, because that would actually probably be grounds to have her removed from the case. But he has praised her on many occasions in his special wink and nod way that he does, his mobster way. She's a fine judge. And even in their filings, Andy, we've seen so many times where it's despicable that Jack Smith said that to your honor, like that kind of a thing. There's a lot of that kind of, I think, bootlicking robe licking. I don't know what you call it. Going on. But of course she wants to be a Supreme Court justice. And I wouldn't doubt that if Trump were to win a term, I happen to pretty much know that Alito and Thomas would retire because their spouses
seem to be a little sick of it.
I don't want to say drunken rants, but after a few martini rants to Lauren Windsor, made it clear that, once he gets to step down and this is all over, I'm going to fly whatever flag I want,
Going to let her freak flag fly.
So they both sort of expressed that there's an end coming to their terms. And I would not put it past Donald Trump to put Judge Cannon, although usually you don't pull them straight from the district court. They usually come out of a circuit, and they usually come out of the DC circuit. And he's got some appointees there that he might consider first. I don't know. And
honestly, he's not that loyal.
No.
He might like her today, but if he's president and he has an opening to fill, I'm sure the aperture will be a lot wider than just one district court judge in Florida. So
he'll probably expand the court.
These are kind of goofy games to play, to think about these things in your head. But at the end of the day, not really relevant to what happens in the case. Is she making these decisions because that's what she wants? Who knows? The thing that's most important for us to focus on is these are the decisions she's making and what effect do they have on the case. I don't think there's any I know I can almost hear half of our listeners howling when I say this, but I don't think there's any really solid evidence of bias at this point. Is it a possibility that she's biased and she's throwing these things for Trump? Sure. But we're not to the point where it's clear that the 11th Circuit's going to throw her off the case. That's all I'm saying.
Right. I think about it as, Bill Barr, when he wrote that, his memo, his application to be Attorney General. There was no direct evidence that is what he was trying to accomplish, but it worked. And it was kind of obvious to all of us watching, but obvious doesn't get you legal results all the time.
That's
so that's what they consider circumstantial. Anyway, thank you so much for your questions. Brilliant questions. Please send your questions to us. Click on the link in the show notes and you can ask us anything. And I think we may have a clearer picture of what Jack Smith intends to do, perhaps by the next episode. At least I think we might see a motion for an expedited briefing schedule for the 11th Circuit, and we can go from there. And as of course we aren't going to see anything till the first week of August in any movement in the DC immunity situation.
If he's going to move for expedited, you do it quickly. That's the point of expedited. You don't sit around and be okay, let's do it now. So I agree with you. If they're going to do it, it could come soon, because it doesn't mean that that's them filing their brief. It just means they want to start a shorter clock running So yeah, we'll see what happens.
Yeah. Yeah. And I just checked the docket. Nothing yet.
Nothing
so
yet. All right, good. We'll have something next week to talk about.
Yeah. All right. Because we never have, just not enough, never enough news.
For sure.
To fill a whole hour. There always is enough news to fill a whole hour. Thank you so much. And Andy, thanks to you. And of course, thanks to everybody who came out to see us live. That was amazing last week.
Super fun. And thanks for having me. It was a great experience.
Mm-hmm. And we'll be having another live show with Andy, Pete, Glenn Kirshner, Brian Greer, our SEPA expert.
Nice.
On August 16th in DC. There are still tickets available, but I don't know how long they'll last. So take a trip out to the nation's capital.
Heck yeah. Come on
with your
down.
girlfriend Jenny and come and see us at the Hamilton. All right. We will see you next week. I've been Allison Gill.
And I'm Andy McCabe.